Welcome to The Source, where we combine the headlines with in-depth conversations with the newsmakers themselves. Today on the program. It's final. Maria Lourdes Sereno is no longer the Chief Justice.
The Republic of the Philippines, represented by the Solicitor General versus Maria Lourdes P.A. Sereno, denied with finality the respondent's motion for reconsideration.
Sereno insists the Duterte administration was behind her ouster.
Lahat ng ito ay nagsimula nang si President Duterte ay naupo. The responsibility for the weakening of the rule of law is his.
But Malacanang denies this, saying it's about time to accept the Supreme Court's final decision. Meanwhile, the search for the next top judge is on.
The 90-day period for filling the vacancy in the office of Chief Justice commences today.
Integrated Bar of the Philippines President Abdiel Fajardo and lawyer Vitangcol join us live. And later, newly discovered animal fossils were named after two famous individuals. Who are they? That's for today's In Focus. Thank you for joining us. I'm Pinky Webb. The Supreme Court affirms its decision to oust Maria Lourdes Sereno as Chief Justice. In a full court session Tuesday, the High Tribunal voted 8-6 to junk Sereno's motion for reconsideration. Sereno sought to overturn the Supreme Court's ruling granting Solicitor General Jose Calida's co-warranto petition. Malacanang says the ousted Chief Justice should respect the High Court's decision, while an opposition lawmaker is considering filing impeachment cases against the justices who voted to oust Sereno. Let's go straight to the sources of the story we have here in the studio. Attorney Larry Gadon's lawyer, Attorney Vitangcol, and joining us via video call is Integrated Bar of the Philippines President Attorney Abdiel Fajardo. Good morning, gentlemen. And let me start with Attorney Fajardo first. Sir, your reaction to the Supreme Court's final decision yesterday?
Well, of course, we were disappointed with the denial of the motion for reconsideration filed separately by the Chief Justice and by our group. But with disappointment, we will try to set up forums for people to express their views on this decision of the Supreme Court. But of course, as a matter of law, as the law of the case, this is final, so we have no choice but to move on from here on.
Is there any other possible recourse, sir? I know you said that this is final, but can anybody go to another body and question this?
Well, as far as judicial recourse is concerned, I think that's the end of the road for this case. No? Even if the Senate will say that they have jurisdiction, there is no case before them. So I think at this point, it really is sort of a dead end already for this case.
So, tapos na po?
Yes, as far as the Republic versus Sereno is concerned, I think so.
Attorney Vitangcol, sir, it's good to see you again. It's been a long time, sir. You are the lawyer of Attorney Larry Gadon.
Yes, I
am. You are representing him where, sir? In what cases?
I'm actually representing him in the disbarment cases filed against him.
Which we can talk about a little later on. Of course, this all started with the impeachment complaint
of
Attorney Larry Gadon before the House, before Congress, rather. And, of course, there were proceedings at the House of Representatives, and eventually, dito nga lumabas yung supposedly non-compliance of the Statement of Assets, Liabilities, and Net Worth, sir, of the Chief Justice, the former Chief Justice, sir. The action on the camp of Attorney Larry Gadon and yourself, sir.
Of course, Attorney Larry Gadon is elated, no? Considering that the decision to oust the Chief Justice from the Supreme Court is now final and executory. In fact, the May 11 decision is executory in nature, but it's not yet final. But with the June 19 resolution now, it's final. So everybody can now move forward. And in fact, Larry Gadon is happy about that because it would spare him and the House of Representatives from the grueling trial of the impeachment case if it was to go up to the Senate.
If it was transmitted to the Senate. So he's happier that there was a, you're saying that he's happier that there was a quo warranto rather than the impeachment?
Yes, that's correct.
So, yung pong pinagod ni Attorney Larry Gadon, for example, at the House of Representatives, you're saying it's all worth it because eventually the Chief Justice was taken out of office.
Yes, the objective was achieved. No?
Yeah.
It's actually the same result, whether it was for the impeachment or the quo warranto, the result would be the same, the ousting of the Chief Justice.
That's the, all right. But, you know, there are, of course, lawmakers who are saying, both attorneys said that the camp of Sereno could or should file a second motion for reconsideration. Senator Kiko Pangilinan was urging, or rather is urging, the camp of Sereno to file another one. Let's put that up on the screen. We can still adopt it. But this is, again, this is in reference to the resolution at the Senate, but I doubt it if the majority will support it and instead say that the matter is moot. We urge the parties concerned to file a second motion for reconsideration. Attorney Vitangcol, is this even worth it?
I don't think that will be possible now, considering that in the latest order given by the Supreme Court, it says there that no further pleadings will be entertained in that particular case, meaning that a second motion for reconsideration will now be denied outright. And
Attorney Fajardo, do you agree with Attorney Vitangcol, sir?
Well, as far as the rules are concerned, no, whether it is the rules of court or the internal rules of the Supreme Court, a second motion for reconsideration is really not allowed. And of course, unless the composition of the court changes in the meantime, well, the probability of a second motion for reconsideration actually being entertained, I think is quite nil at this point.
Okay, I want to ask both gentlemen, as lawyers, what does this actually really mean, number one, for the Chief Justice? I just have, I need to be clarified on this. Number one, attorneys, does this mean that she was never a Chief Justice, or her being Chief Justice was just invalidated? And my next question would be, what about all the cases that the Chief Justice heard and penned, possibly penned, and made a decision on? Attorney Vitangcol, let me start with you, sir.
Number one, if we will go directly to the epilogue of the May 11 decision, it would clearly state there that there was never a valid appointment. So that would simply mean that Attorney Lourdes Sereno was never appointed as Chief Justice.
So she was never Chief Justice?
Yes. So, in fact, that is the outcome of the quo warranto petition. Her name will be removed from the roster of Chief Justices.
I know, because when we look at the website, sir, even during the first decision, I believe, when you look at the website of the Supreme Court, the Chief Justice picture was blank. There was no name Maria Lourdes Sereno there. That was shown, and even until now, during the second decision. So, attorney, you're saying that ganon, she was never Chief Justice?
Yes.
Hindi siya umupo bilang...
Never. And in fact, she can never use the title former Chief Justice because she was never appointed as
Would it be wrong for us, tama? Are you telling me, sir, it would be wrong for us to say former Chief Justice?
Yeah, that's correct. She should be addressed merely as Attorney Lourdes Sereno.
Attorney Fajardo, do you agree, sir?
Well, yes, this actually highlights the absurdity and the ignominy of this decision, no? Because she's been sitting for 6 years as Chief Justice, and now she is considered a usurper, meaning that in all those years that she was sitting there, she was not really sitting there. That's the net effect of this decision. But of course, the decision is also careful to say that she might be a de facto officer of the government during those times, so that her decisions while sitting as Chief Justice or Associate Justice of the Supreme Court would still be valid under current jurisprudence.
So, was she Chief Justice, sir?
Well, she was never Chief Justice, if that is the tenor of the decision, because a quo warranto petition actually, or a decision granting quo warranto actually declares the person, the respondent, a usurper of the public office.
Sa Tagalog, pagka sinabing usurper, Attorney Fajardo, ano ho ba? How would you say that in Filipino? Parang...
huwad na pag-aangkin. I'm not really sure on how to translate. I'm Ilonggo, so I'm sorry. Yeah.
Parang, attorney.
Ng abuso sa
Usurper ng abuso? Yeah, pero I guess I'm trying to understand it. Kasi kung sabihin nyo ng abuso, that doesn't necessarily mean that you never held the position. Nang abuso ka lang sa posisyon, di ba? That's why I guess. So, Attorney Fajardo, do you also agree that she should not be called former Chief Justice? Ganun
Well,
ba yun?
personally, as far as I am concerned, of course, legally, it is my position that until this time there is no vacancy because, to me, the decision is unconstitutional, no? And of course, practically speaking, I should stay if I am asked what I know about Chief Justice Sereno. I will say she is still Chief Justice, but we have to face the reality that the majority of the court has spoken, and that, syempre, as a matter of courtesy, I will still say she is the former Chief Justice.
Yeah, but sir, being the president of IBP, and I know you filed motions for intervention on this, but now that the Supreme Court has spoken, you're both saying that the Supreme Court is saying she was a usurper, she was never Chief Justice. Hence,
Correct.
whether I hope it's okay, but I need to kind of like separate your you know, deciding on this or thinking about this as unconstitutional. I understand that, sir, because you believe that impeachment is the only way. But because the Supreme Court has spoken, you need to respect that, and hence that means that she was never Chief Justice.
Yeah,
Tama
we have
ho
to
ba?
accept that. Yes, we have to accept that. It's the first job of a lawyer to be able to accept a decision on a particular case. But of course, we have our views on that, and we will continue to advocate that this particular decision is a blot on the history of the Supreme Court, and has to be corrected in some other case.
And could it be corrected sometime in the future, sir?
Well, there is always a chance of reversal in another case, no? Because in effect, this allows the Supreme Court, this decision allows the Supreme Court to remove one of its own. And we have consistently contended that the Supreme Court has the power to remove only lower court justices and judges, and not one of themselves.
Not one among their colleagues. We'll be taking a short break. This is The Source on CNN Philippines. Still to come, after his winning the Quo Warranto case versus a sitting Chief Justice, is the Solicitor General the most powerful man? IBP President Abdiel Fajardo and Attorney Vitangcol will weigh in after the break. Also, new fossils were found in Australia and named after two iconic individuals. Who are they? Find out on today's In Focus. You're watching The Source on CNN Philippines. Our guests today, Integrated Bar of the Philippines President, Attorney Abdiel Fajardo, and Larry Gadon's lawyer, Attorney Vitangcol. Sir, you were saying during the break that it could have been, or another alternative would have been, if the, now I don't know how to call her, if the, if
Attorney Lourdes Sereno.
I need to find out if that's correct, but yes, if she had resigned, hindi po siya matatanggal as Chief Justice. Hindi po matatanggal yung kanyang pangalan bilang Chief Justice. Is that what you were saying?
Tama yan, Pinky, no? If she resigned, no, even during the middle of the proceedings, her name will not be removed from the roster of Chief Justices. It would simply state there, Chief Justice Maria Lourdes Sereno, from the time that she was appointed until the time that she resigned. So, nandun pa rin yung pangalan niya.
And I guess the next question would be, if that is the case, because she did not resign and she was taken out, removed because of a quo warranto, what about the cases that she handled?
They will still be valid, considering that all decisions are done by divisions. So it's not only hers, no, that would have signed any decision.
Right.
It will be a collegial matter.
But Attorney, what if, please correct me if I'm wrong, if it was a close decision, and she had signed on as part of to tilt the balance towards one person, baka questionin ulit po nung taong yun dahil
she will no longer be there.
She's no longer there, and it's as if she was never there.
That is a big possibility. For example, if I am a party to a case and I know that the voting is so close and there is only one difference, and that difference is Attorney Lourdes Sereno, then I might question it. But if the difference in the vote is not Attorney Lourdes Sereno, then it will have no effect.
Sabihin po natin, for example, may kaso po ako. The vote, I don't know, sir, let's say was
8-7.
8-7, di ho ba? And then 8 was the Chief Justice. So now I can, and I lost. I can question that again before the Supreme Court and say, well, there was never a Chief Justice Sereno there, so that vote should have been 7-7.
It might be a possibility, and let's see how the court will react to that. It never happened. So
yeah, I know, because even this is the first time this happened. So there's so many possibilities. Let's get the reaction of Attorney Fajardo. Attorney, I'm wondering if you heard my question kay Attorney Vitangcol, sir, regarding possible cases that the Chief Justice had decided on or signed on to, sir?
Yes, I heard, Ricky.
Paano ho yun? An example would be, I have a case, for example, sir, and the vote was 8-7, and the 8, and I lost, sir, and the 8 is Chief Justice Maria Lourdes Sereno, Attorney Sereno po.
I'll give you a concrete example, Pinky, no? Okay. A concrete example would be the case of the citizenship of Grace Poe. Remember, it was an 8-7 vote, and the very slim majority there, the 8 said that Grace Poe was natural-born Filipino, being a foundling. And the 8th justice who affixed her signature agreeing to that decision was the Chief Justice, Chief Justice Sereno. If we are to entertain the idea that, as a usurper, she was not really there, it is as if she was not there, that would be a very difficult proposition. And I think the solution would be to say that she was a usurper, but she was a de facto officer while sitting as such in the Supreme Court, meaning that all her decisions would still be valid, there being a color of title to her position as Justice, Associate Justice initially, and then eventually as Supreme Court Chief Justice. So there are innumerable difficulties if we are to strictly say that it is as if she was not there for the past 6 years.
Yeah, it's as if she never existed the past 6 years, because I would question that if I had a case, because it's as if that one person was never part of that case, if you're telling me that she was never part, or she was never a Chief Justice. But,
yes, correct.
But Attorney, who's to tell us how this will all pan out? Is it still going to be the Supreme Court? I mean, once we read the entire decision, possibly, will they be the ones saying that, just to simplify it, Attorney said that she was never Chief Justice, but all her cases will not be affected. Pwede ho ba yun? Can the Supreme Court, can the Justice of the Supreme Court actually say that? Attorney Fajardo.
Yes, of course. Under the de facto officer doctrine, the court will say even if you are a usurper, all acts done while in office have a color of title. There's legality to it. Therefore, all those decisions will stand. I think that will be easy pickings for the Supreme Court.
So pwede pala yun. Pwede nilang sabihin you never existed, but all the decisions you made existed?
Correct. That's correct.
Attorney Vitangcol.
Yes, considering that the Supreme Court is the final arbiter of everything, so it's up to the Supreme Court to declare that, if somebody will question it.
Yeah, but do you agree?
Well, I agree. No? I agree with the views of Attorney Fajardo. No? I agree with that, considering that there is always a presumption of regularity in what is done in government agencies. And all these decisions are collegial in nature. It's not only done by Attorney Sereno. It was done by a division or an en banc. So it should be valid up to
I
now.
understand that, but it's an en banc decision. But if it's a vote of one that will tilt the decision one way or another, that's what I'm questioning.
Yes,
that's what I don't understand,
yeah,
sir.
that will now be a big question mark also if the party concerned will question it before the Supreme Court.
Attorneys, do you think that there will be people, Attorney Fajardo, who will question some of the, look, we're looking at about possibly 6 years of an 8-7 vote. I don't know how many they are, of course, but that they can question this before the Supreme Court. Attorney Fajardo, do you see a number of people possibly going to the Supreme Court and questioning decisions made or against them?
Yes, I'd say it's possible and even probable, especially in those cases where the decision was closely divided.
Pwede nilang questionin yan before the
Yes,
Supreme
but of course, there's always a defense, the de facto doctrine.
Yeah, but then again, is what you were saying, the de facto doctrine, which Attorney Vitangcol also agrees with.
Yes.
Okay,
Yes.
so that's one thing that needs to be, I guess, ironed out. But I also wanted to ask both gentlemen, sir, we're talking about a former Chief Justice, Attorney Sereno, who was never Chief Justice, supposedly, the past 6 years. But there's a group, sir, that, and I think the IBP is part of this, I'm not sure, the JBC, who gave this list to the President Aquino, and said, these are your possible candidates. What about the culpability of the JBC? Why are we seemingly forgetting that it was the JBC that gave the President a list of the candidates for Supreme Court? Attorney Vitangcol.
According to the decision, if we go back to the May 11 decision, it says there that Attorney Sereno was not forthright, and she concealed the fact that her salients were never submitted. So there was concealment from the JBC. As far as the May 11 decision is concerned. But as to what happened in reality, I do not know.
Oh. Attorney Fajardo, sir.
Well, I understand there are currently administrative proceedings, separately from the main decision here, being undertaken or being conducted by the Supreme Court itself. So we'll know how they will dispose of this administrative proceeding.
I guess I want to
Eventually.
go back. Is the IBP part of the membership of the JBC, Attorney Fajardo?
Yes, we have one representative in the JBC.
There you go. Who was the
Yes.
representative back then, sir?
It is Justice Milagros Fernan Cayosa.
I see. Okay.
Yes.
So I just think that her name would have never been part of the list if the JBC never submitted the list to President Aquino back then. Would you agree, gentlemen?
She would not be chosen if her name is not
Yeah.
on that list.
So is there culpability with the JBC, sir? Attorney Vitangcol?
I cannot say with finality if the culpability is with them, considering that the May 11 decision
Hindi,
states
may
that
pagkukulang kaya sila, tingin ninyo?
pwede, but I'm not saying there is.
Okay, what about Attorney Fajardo?
Well, we have maintained the position that the matter of the question of integrity, competence, etc., are exclusively matters exclusively within the competence of the Judicial and Bar Council, and eventually of the President. No? So that is something that is not justiciable. That is our position. So at this time, we're saying the JBC is not culpable, no, unless it was made a party to the quo warranto petition or another petition, certiorari perhaps, precisely presenting to the court the facts that transpired, prior to the appointment of Chief Justice Sereno. But they were never made a party. In fact, one of the justices pointed this out in his dissenting opinion, that what are we doing here? The JBC is not even a party to the proceedings, and we are actually reversing their determination of integrity. So that is just one of the legal anomalies that we have been voicing out in various fora.
I see. Let me ask also both gentlemen your thoughts on this, belief that the Solicitor General, having filed this quo warranto, could be or is touted to be the next most powerful man in the country next to President Rodrigo Duterte. Attorney Vitangcol. Siya na ho ba yung pangalawang pinakamakapangyarihang individual?
I don't think so, considering that the Solicitor General is simply representing the state. So he is not acting on his own, he is acting on behalf of the state.
And you don't believe that the camp of Sereno is saying that the President had something to do with this and had told the Solgen to possibly file this quo warranto, sir?
No, we believe that the action of the Solicitor General came about because he discovered, among other things, that Attorney Sereno failed to comply with the requirements, and this was brought about by the impeachment complaint
of Attorney
filed by
Larry Gadon.
Attorney Larry Gadon before the House of Representatives.
Okay, an answer from Attorney Fajardo, please. Will this
Yes,
make the Solgen?
Yes, I agree with the dissenting opinion of Justice Caguioa. No? We have made the Solicitor General actually one of the most powerful persons in the Executive Department, because all constitutional officers now, Commission on Audit, Civil Service Commission, Office of the Ombudsman, even the Supreme Court Justices, may be subjected to quo warranto proceedings initiated by the Solicitor General.
All right. Attorney Integrated Bar of the Philippines President, Attorney Abdiel Fajardo, and of course, the lawyer of Attorney Larry Gadon, Attorney Vitangcol. Maraming salamat po sa inyong dalawa. Thank you, gentlemen.
Thank you, Pinky, for having me here.
And thank you, Attorney Fajardo. This is The Source on CNN Philippines. Coming up, newly discovered fossils were named after an American president and a lover of science. That's for today's In Focus.